Hello and welcome to News Center. I am Ashmit Kumar. Now, the top story this evening. In a big blow to the United States President Donald Trump, a federal court has blocked his so-called reciprocal tariffs under emergency powers. The Court of International Trade in New York declared the orders issued on what Trump called Liberation Day as illegal and as an overreach of executive power. The Trump administration was swift to appeal this ruling. Trump is yet to respond to the ruling, but a White House spokesperson claimed that unelected judges cannot decide on how to address a national emergency. Let's quickly sum up the court order. In fact, Trump's 10% baseline tariffs as well as the reciprocal tariffs levied on countries around the world become null and void. The other executive orders that have been struck down render the fentanyl tariffs levied on Canada, Mexico and China invalid. The court has also struck down the 25% tariffs levied on goods not covered by the United States-Canada-Mexico agreement. However, that the 25% tariffs on steel and aluminum remain unaffected by the court orders as they were imposed under a different act. Also, Trump still has enough legal ammunition to impose tariffs. And well, joining us now to take this discussion ahead is with us Mr. Jayant Dasgupta, former Indian ambassador to the World Trade Organization. Mr. Dasgupta, thank you so much for joining us. Help us put this development in context. The U.S. court viewing things very dramatically different from what Donald Trump has been pitching it as justified as reciprocal tariffs. The U.S. court saying, look, this is an overreach of your executive powers. Put this development in context. What does this do to the tariff battles that we have been seeing over the last very many days, weeks?
There are 4 points which have been highlighted in this order of the Court of International Trade, New York, which is a federal court. And we need to bear in mind that there is an appeal which can be filed within 10 days in the Federal Circuit Court of Appeal. And if one of the sides loses and decides to appeal, then the final appeal will lie with the US Supreme Court. So it is likely to take a few weeks at least before a finality is reached on this decision of the Court of International Trade. Now, the most important thing on which the Court of International Trade has ruled against the Trump tariffs is that this is a delegated power which was given to the president. And the delegated power cannot be without any bounds or limits. And if the delegation has been done without specifying under what conditions it can be exercised and what would be the boundaries, then it is invalid. So on that count alone, the Trump tariffs have been struck down. The second point is that President Trump has been saying that there is a trade deficit which the US suffers from. Now, the court has mentioned that there is a Section 122 of the Trade Act 1974, which says that for 5 months, 150 days, tariffs up to 15% can be imposed to tide over a trade deficit situation. So that President Trump can use, but it will be restricted to 150 days and only for up to 15% of tariffs. The third point is this national emergency which he has invoked, that has not been upheld by the court. The court did not see enough reason to uphold that, barring, of course, the issue of steel and aluminum tariffs, which have been allowed to carry on. The next point is about the applicability of the tariffs. Applicability of the tariffs. The Court of International Trade has mentioned that it should apply to the whole of the country because tariffs, excise duties, etc., they all apply uniformly across the board. And the Supreme Court has a few matters in the US pending before it on this issue. So this will give finality if the appeal goes up to the Supreme Court as to whether it should be applied across the board all over the US or selectively. So these are the few
Right, Mr.
issues.
Dasgupta, Right, Mr. Dasgupta, you've given us valuable insight. Let me then ask you, this court ruling was limited to striking down the tariff orders that had been issued under the International Emergency Economic Powers Act. That's the legislation under which all tariff orders that were issued were struck down. However, like you yourself pointed out, tariffs on aluminum, on cars, on certain specific products have not been struck down. It's because they were passed under separate legislation. Are we all looking at a possibility that Donald Trump, if he loses this legal battle, could simply revive these tariffs under a different legislation, under a different law?
Well, under Section 232, which he had invoked even in his first administration, for invoking steel and aluminum tariffs on the national security issue, that can be used by President Trump, but that is also subject to challenge. Now, in this case, there were a few small business enterprises and associations which had filed the case, along with some Democrat-ruled states. So, were he to extend the steel and aluminum tariff example to cover all the other products that he has covered under reciprocal tariff, I'm sure this challenge will again be made about whether a condition of national emergency exists or national security concern of grave, of gravity is there to justify.
Right. Mr. Dasgupta, you also mentioned the appeal process. Of course, it concludes with the United States Supreme Court. I just want to get your perspective. The U.S. Supreme Court, 9 judges, 6 of them appointed by Republicans, 3 of them appointed by Donald Trump himself. Is he on a stronger footing as this matter travels north towards the U.S. Supreme Court?
Well, from the reports which have come out of the Court of International Trade, there were 3 judges. One was appointed by Ronald Reagan. The other one was appointed by Obama, President Obama. And the third one was appointed by President Trump himself in his first stint. So I think the judges have not really, been moved to who has appointed them and their political inclinations. They have risen above that, and they have given judgment which can be tested in the Federal Circuit Court of Appeals and in the Supreme Court later. And I think that the U.S. Supreme Court will also, because this is something which is of great importance and significance, because it tests the U.S. Constitution, the delegation of powers to the president, whether they are unfettered, if they have not been, the boundaries have not been specified by the legislation to delegate powers, or there will be fetters. So it is a major constitutional issue because it will have a bearing on subsequent actions of this president as well as successive presidents on the powers of the president and the standing of the U.S. Congress.
Right, Mr. Dasgupta, thank you so much for joining us. Clearly, this will be a long-drawn affair. The Trump administration, of course, has taken the legal remedy of appealing this order in the United States Court of Appeals for the Federal Circuit. So clearly, it's going to be a long-drawn battle. But in the short term, in the near term, there is some reprieve. At least the markets are giving a sigh of relief. The markets going up, even as this order came up last night. But Mr. Dasgupta, thank you so much for joining us, for sharing some more perspective on this. But with that, it's time now for a very short break. But coming up, defending the tariffs in court, the Trump administration argued that any legal setback could put the India-Pakistan truce at risk, in jeopardy. A special discussion when we come back.